Here we are at the end of American courts. We're talking about the appellate process a bit more. Appellate courts as decision makers. Why do appellate courts act the way that they do? Well, there are different perspectives. One, the legal perspective, the personal perspective, and the environmental perspective. Usually at the first level, meaning the appellate courts directly above the trial courts, the legal perspective tends to dominate. That is to say, you apply the law and the rules to the facts, and if the trial court got the law wrong, you remand. At the second level, the personal perspective, that is the policy decisions of the judge or their personal uh, uh, personalities, or the environmental perspective, which is kind of what's going on in society, that tends to dominate. Um, what accounts for the difference in votes between conservative and liberal judges? The law is the same. The social environment, that is to say, what's going on in the country, tends to be the same. So oftentimes, the default is that the difference between, for example, Clarence Thomas and Sonia Sotomayor gets chalked up to their personal policy preferences. The law, as it exists, is the same for both of them. The country is the same for both of them. It's how they personally view and believe the country should operate. That's why the makeup of these courts is so important. That's why when an executive chooses a judge, or a governor chooses a judge, um, that's why it's so relevant, because it's not a matter of the law being different for judges most of the time at the appellate level. It's not a matter of the social environment being different. It's a matter of the individual judges wanting different things. Now, at the appellate court level, especially at the Supreme Court level, there's a really interesting kind of group dynamic thing that goes on. Appellate courts issue majority decisions, majority opinions. So there's an incentive to cultivate a majority. There's an incentive to work as a group to craft an opinion that the majority supports. You're trying to persuade your colleagues. You're trying to sort of explain to them why you think you're right. If you're an iconoclast and you want to go off and stand on your soapbox and say your own thing, well, you might get a lot of attention, but you might not get a lot of opinions that agree with your position. At the Supreme Court level, they have discussions during oral arguments. The judges oftentimes ask questions of the lawyers, but oftentimes those questions are really questions for other judges. The judges use the lawyer as kind of a ping pong table to bounce questions back and forth among themselves. Um, Now, at the Supreme Court level, the Chief Justice is the one who assigns the opinion, right? Um, the Chief Justice at the Supreme Court level, that's John Roberts. He's the one who says, okay, it looks like we're going to vote in favor, and I'm going to assign the opinion, the writing of the opinion, to Neil Gorsuch or Elena Kagan, and then that judge writes an opinion that tries to get the majority to join. But the Chief Justice has a lot of weight in what that opinion will say, because he's able to choose from the majority the person who writes the opinion. Um, Now, obviously, judges are the product of both their local and their national legal environments. They come from places, they come from schools of thought, they come from personal and professional backgrounds. Um, we looked at the fact that every Supreme Court justice up until Amy Coney Barrett, the entire bench was either Harvard or Yale educated. That's a big deal. They both come from this. They all come from the same two schools. The political environment differs, obviously. If you are going to be elected, if you're a judge at a state court level going to be elected, then you have an incentive to kind of take the political temperature of the community, and that might put pressure on you to um, rule in ways that you feel would be politically popular. Why do appellate courts make policy? because appellate rulings bind the lower courts. Remember that. If an appellate court, the Ninth Circuit in California, or the Supreme Judicial Council in Massachusetts, when they make rulings, those rulings are binding on lower courts, binding precedent. So it's a big deal. That's how they make policy. When the Supreme Court makes policy, whether it's about your right to carry a firearm or your right to same-sex marriage, those policies cover the entire country, and every court below the Supreme Court is bound to follow the precedent. Next module, we're going to spend some time reading appellate court opinions because they're the ones that make policy. And so it's important to talk about how those things are shaped. Usually, in an appellate court opinion, the first part will be a recitation of the facts and how the lower court treated the parties. They'll explain what the facts were at the trial court level, what the witnesses testified to, what the evidence was, and then what the judge at the lower court ruled. Then there'll be a discussion about the legal rules that the lower court applied. And almost always, as we said before, appellate courts don't touch findings of fact from the lower court ruling. Appellate courts don't want to exacerbate tension between the trial courts and the appellate courts, and they don't want to increase their own caseload. So they tend to defer to the trial court on issues of fact. Not always, but sometimes. Supreme courts, that is, say the U.S. Supreme Court or a state Supreme Court, do disturb lower court rulings at a higher rate. Why? Because they don't take the case until they think there's an issue. Remember that when jurisdiction is discretionary, they don't have to take the case. So if they hear the case, it's because they think, or at least some percentage of the justices think there's a problem. The bottom line is that most trial court rulings stand. It's only when there are divisions between states or there have been egregious errors that you get to the appellate court level. Despite that, once you do get to the appellate court level, there are broad, direct, and indirect effects. We've talked all about state Supreme Courts. We talked all about state Supreme Courts and how they'll often hear plenty of appeals from criminal matters. Why? Because criminal defendants have little incentive not to appeal. If you're doing 20 years for a crime, you're going to appeal. And why not? You have plenty of time to do so. And there's not a whole lot of cost involved if you're doing it yourself. The U.S. Supreme Court hears a number of civil liberties cases, constitutional cases, public law cases. And most of the time, historically, appellate courts tend to be conservative. And I don't mean conservative with like a capital C, political conservative. What I mean is courts tend to be very deferential to the way things have gone, to the rules that have come before. Courts serve a function of providing guidance to the community about what is acceptable and what is appropriate, and changes as to what is acceptable and appropriate happen slowly. Now, of course, they were also conservative because they often, at least historically, always resembled each other from court to court. As I said earlier, for a very long time, the Supreme Court was entirely white men. And as the makeup of the court changes, the experiences and the perspectives that the judges bring to the bench change, and so you do see more liberal rulings now that the makeup of the court changes, and that may be a good thing as well. When we hear the term judicial activism, that tends to be someone saying, "Oh, this unelected judge or this appointed judge is doing something that is outside of their job description. They are being a judicial activist." And these rulings that judges make do have effects, right? They can change. I mean, for example, you're too young to remember this, but when Al Gore ran against George Bush, there was a lawsuit about whether or not Florida had to recount all of its votes. and the Supreme Court stepped in and said they did not have to recount all the votes, and that the Secretary of State in Florida could make a ruling on what the actual electoral tally was. Now, the court in that case was very clear in its ruling to that ruling applied only to the case Bush v. Gore. So it was a very narrow ruling, but that had the effect of deciding the presidential election. Other rulings, like the one in Citizens United, which is a case involving political spending and contributions to political campaigns, that was an extraordinarily broad ruling that has been interpreted to apply to all kinds of contributions to political campaigns and money in politics. They can be hugely consequential rulings. Now, why is judicial activism on the rise today? Well, sometimes these judges come in an environment in which they've been cultivated in an environment of partisan politics, and so they come in with strong and specific policy goals, as opposed to professional goals to be a judge. They might come in, they might be appointed, or they might have their campaigns funded by people who say, we're putting you on the bench because we like your policies, or we like your politics. Another reason it's on the rise is because there's a huge growth in government action outside the courts, and interest groups getting involved in causes. Interest groups can raise a lot of money to both put judges on benches, or also to advocate for certain policy positions that can result in requests that judges change the law. Now, this is really important to think about. Once the courts rule, what happens next? Let's say that the Supreme Court issues a ruling, that says that let's say in 3 years the Supreme Court issues a ruling that revokes the right of individuals to carry firearms, or let's say the Supreme Court in 6 months issues a ruling that changes the timeline for voting rights, let's say. Well, what happens next? The Supreme Court does not have an army. The Supreme Court does not have police that go out and enforce its rulings. They have to be implemented by the institutions that they govern, and that is not always done right away. For example, Supreme Court rules on school prayer or Bible reading activities. Even though the Supreme Court might say that you can't do that, some schools still do it. In fact, there's a bit in our books saying that non-compliance with those kind of rulings continued up until 1990. There was a huge issue with Brown v. Board of Ed. You will recall, I hope, that in Brown versus Board of Education, the Supreme Court decided that separate but equal educational systems were not allowed. That the 14th Amendment, among other things, protected students from being part of educational systems that were separate but equal, or that were described as being separate but equal. And after Brown, the court said, with all deliberate speed, you had to integrate all the schools. It took decades for those schools to be integrated because decision makers in the Deep South dragged their feet, and it took the National Guard and courageous students and lawyers to really make that desegregation happen. It took decades. Now, what can judges do? Well, they can issue sanctions against lower courts or administrators for failing to implement policies and rulings. They can overturn rulings from the lower courts. They can issue contempt citations for willful failure to implement orders, but they don't have within themselves the strength or the resources to actually impose their rulings on the country. So our final issue here is whether or not courts lead policy changes, they follow policy changes, or something in the middle. We're talking about Brown v. Board of Ed, eliminating school segregation, but nothing happened for a decade. Women's rights have grown, but they've also been challenged since the 60s. And the procedural rights of criminals have grown since the 60s. And while our textbook says that you should use caution in describing massive effects of court decisions, decisions have huge effects, both directly on the parties, but also on social behavior, and they can also be triggers for much more widespread societal change. Thanks for this, and we're done with